This is part two of my recording with David Higgs, who's come to try and help me sort out my brain.
Yeah, I'm gonna jump into your brain and push some buttons and pull some levers and see what happens.
Right, so I'm going to go to these acts, all right? So I'm share the window. So can you see these acts here?
Yep.
Right. So are they quite clear? Can I move this? I think I can move this over here. And that will show up over here. All right, I think I can do that. Yeah. So you'll look here, and this will say to you from 1275 all the way to 2022. And this is called the New Zealand Acts. Now, what has happened is the English law is 1275 all the way. The English, you see here the 1688.
Yep.
And what you'll see here, I'm going to show you another one in a minute. The English law here goes to 1852, which was the Wills Amendment Act, 1852, UK. And you should see here, you'll see here 1843, which is the Judicial Committee Act, all right? And this was the Judicial Committee Act set up in New Zealand. And you'll see here 1837, there's the Wills Act. So 1837 is the Wills Act, UK, and England came to New Zealand in 1839. And in 1843, the Judicial Committee was set up. But you'll see you won't be able to see it all, but there's various acts missing from here. So this is clipped on, all these laws here from, let's see, let's go to 1975. And if you go to 1975, you'll see this thing here called the Treaty of Waitangi Act, 1975, right? And here is the Treaty of Waitangi Act, 1975. But it comes from a 1975 Act, number 114. And under this Treaty of Waitangi Act, this one has had many, many, many alterations. And the main alteration comes here. So this one says, where any Maori claims that he or she, or any group of Maoris, which he or she is a member, is likely to be prejudicially affected by any ordinance of the Legislative Council of New Zealand or any ordinance of the Legislative Council of New Munster. Now, New Munster is the South Island, and previously, and then it says, now this is what I want you to read, passed at any time on or after the 6th of February, 1840. And then it says anyone affected, it says it in B as well, any regulations, orders, proclamations, statutory instruments made, issued, given at any time on or after 6th of February 1840, or is affected by any policy by on or behalf of the Crown or any policy proposed by the Crown, or is affected by any act done or omitted at any time or after the 6th of February 1840. Then there's a whole bunch of stuff here that has been added, and there's actually 3 of these Treaty of Waitangi's, but where we are is right down here. All this was added, so all of this is not in the original enactment, none of it. And where we are here, to go, this is all added later. This one is the right to petition the House of Representatives is unaffected. Nothing in this act shall affect in any way the right of any person to petition the House of Representatives for redress of any grievance or jurisdiction of any committee or any body set up by the House of Representatives to deal with a petition to the House of Representatives. Now that is the Supreme Court, and that's where I'm sat now, in the Supreme Court. So I'll get to that in a minute. Now, Section 9 was replaced in 1987 by the Constitution Act of 1986, which removed this right here of mine. So this was my right here to petition against any bills of Parliament was put in here.
Can I interject there for a minute? Okay. Are you saying that this Section 9 deals with a different tenancy agreement than the one that you're saying that overreached it?
I'm saying that this is the overreaching one, and I'll go and show you the original one now.
Okay.
So
okay.
So I'll get there. So you'll see all these laws here, and it goes right through to 22, and it starts in 1275. But I'm going to show you the link up. This is in the English law, and it starts our law from 1841. This is the original tenancy agreement, is all in here, and they ended it in 2007. And if you look in 1841, so if you look here, you'll see 1841, 1842, 1844, and 1847. You'll also see 1858, and I'll show you in a minute. So then you'll see over here that those you'll see only 1843 is there, and those other ones have been removed. So the new tenancy agreement has removed them. And what they're doing is they pass a law through the original tenancy agreement, and then they move over here and they wait for 10 years or so, and they change the law that they passed through the original tenancy.
Okay, I can interject right here instead of going through a lot of this, and whether you've already dealt with this or not, I guess that remains to be seen. Simply, if you're speaking about two different subject matters, okay, and then you're speaking about an overreach, it's not an overreach if the subject matter is different. So it's very easy to deal with. If you're dealing with a subject matter that's in the 1800s, which was promised as a tenancy agreement to be subject, that's a different subject matter to what is now what you're referring to in that section number 9. So all you have to do is go to your Interpretation Act. There's going to be repeals, okay? Look under repeals, and it'll say somewhere along those lines that only of the same subject matter can be repealed, and anything not of the same subject matter cannot be repealed. So you could just go back to that law, which originally sanctified tenancy that you want to deal with, and not even worry about those subsequent overreach, because they have nothing to do with the same subject matter. It's will be real simple for you if you just go into identify the subject matter that you want to deal with, and then only concentrate on that, and do not bring any of that other stuff in. It has no bearing on. As soon as you start commingling, the judge is going to throw you into the one of the latter. You've got to stay with that interest that you're interested in, and not bring anything else in. Like you've wanted for my attention to bring in where the overreach is and this new tenancy agreement. But once you do that, do not pay attention to it anymore. Then what you can do is look into your own case laws and find the tests that then allow you to be subject. There's going to be whatever criteria the judge uses, which when he's listening to you, he's probably using it in his own head before he's writing it. But if you go in create harmony with that test to prove that you are already subject, then again, there is no argument, because you're dealing effectively with the law and the correct subject matter, which will then assimilate with your true status. So it's really simple if you want to deal with only that interest that's pertaining to being subject on the original Will and Mary Constitution, if you will, that then addressed those ancestors that had a right through subject of free and common soccage in New Zealand. Okay, so everybody's on free and common soccage since since the abolition of the Tenures Act of 1660, moved everyone into it, and then we at 1688, the Bill of Rights, the English Bill of Rights, removed the property or the rights to escheat of land back into the monarchy as supreme owner. It now gave the ownership back to the people, to which then create the subjects under there to be under free and common soccage and deal with that common law interest, to which then government then use the equitable interest of that. And that's where you're dealing with those matters of tenancy right now. Don't deal with them. You'll get yourself convoluted, and you'll commingle things. And then at that time, the judge will see that you're not certain of the correct subject matter. Therefore, he can't then provide you the correct remedy. So that's how I would deal with it.
That's a very good thing what you've just said there. Yeah, because that's exactly what happened. That's correct. So in 1840, the rules of sovereignty to the people of the land was already set up. And what happened in New Zealand is none of the kings could agree on. So in England, Scotland and Ireland, they all agreed that all the land would be scooped up and sat in the hands of the king. And then they would, through their Will and Mary, be able to govern. And we were given things called the Bills of Exchange, where we had the right to call them to the court and protest any bill that they make for us. What was happening is the king was taking all the taxes and then he was spending it, but the people kept complaining about how he was spending it. He kind of threw up his arms and they kind of said, well, all right, we'll take the money and we'll put it into this place called Parliament, and you can all vote and you can all say how you want it, and they'll produce the bills. Well, they weren't able to do that in New Zealand. And what they needed to do is to set up a Supreme Court, and courts that they could set up a trust that belonged to that country. And England, obviously, at that time, was not allowed to just go in. They were allowed to set up a scaffolding government until such time as that country, that's why they went to 54 countries, till such time as that country was able to set up their own Supreme Court and everything. And what happened was, in 1840, so we'll just go back to here. again. I'll go to the share screen. So I'll go over to the, so in 1841, you'll see the Supreme Court Act, and it's a number 1. And you can't have a Supreme Court without subjects, which are the people. So this was the Supreme Court Act of New Zealand, and all the courts were set up. So this was the number 1, and then the county courts were set up as a number 2. And previously to that, New Zealand was under the New South Wales, and you see here that's a number 2, and it was repealed through the 1841. So when the Supreme Court was set up, and then what you'll see here is in 1842, you'll see the lands, claims, and the postage and everything all set up. And then what had happened here is you'll see in 1844, they brought in these people called the German Settlers Act. Now, this is, you'll see that it is a number 2. And then you'll see here the Union Bank of Australia, which is a number 1, and then the Supreme Court Rules Act, which is a number 1. So these acts, so if you go to the German Settlers Act, this group of people came to New Zealand on the 14th day of June, 1843, and they were made natural-born subjects of Her Majesty. They were not made British nationals. You can go and read here. What it basically says here is that all in singular, the persons who are particularly described in the schedule hereto annexed shall be, to all intents and purposes whatsoever, deemed and taken to be and to have been from the 14th day. Oh, no, you have to go here. Certain Germans, being the persons particularly described in the schedule to this ordinance annexed, have recently settled in this colony, and Her Majesty has been graciously pleased to assent to the removal from them of the disabilities to which aliens are by law subject. Now, this here was created before they stepped foot on New Zealand's shores. Whilst they were on the ship, they had their nationality severed from them, and then they were reconnected to the Supreme Court of New Zealand as a subject, because they couldn't, in my view, they couldn't, the British subjects and the British nationals and Scottish nationals and Irish nationals were already subjects, and they were already attached to the Supreme Court of England. What they needed was a group of people with no nationality, their nationality severed from them, and then they connected them onto the Supreme Court of New Zealand and also to the banking system in order to be able to set up the trust, which was to be their tenancy trust. So that was done, and then these people's names were all put on there. And then for mine, there were 5 brothers. One here, this Sixtus here is one, and another Sixtus here, 3, 4, 5 sextuses had their nationality severed from them, and then they were connected up to the Supreme Court. And then you see here, it's a little bit, I don't know why they've done it like this, but you'll see the Union Bank of Australia, and then this was the stock company, and you'll see that it is number 382 and 383. You'll see 383. Then you'll see 384. And then you'll see 385. Then you'll see 386, 387, and then here you'll see 388. And this is the schedule of the AB. We are called AB, which is a mathematical equation of the two circles. One is the A, one is the B, and when they're linked up together, there'll be a middle section. And it's the middle section where all things are created for both of them. So this was the Union Bank of Australia, and this was where the trust, Queen Victoria Trust, was set up. Now, if you see here, it is a number 2, and it's number 388. This is actually supposed to be attached. Here, this is part of this where the numbers have been removed, because this is attached to there. And here, that was 388, and then here is 389 with all of the names. And then, so that is what has been removed. Then if you go to, 1975 here, and you'll see the Treaty of Waitangi, number 114, the original. So all the original documents are created within this construct. And so it must be, and then once they get it ascended, so this was ascended, and then in this one, it's very, very different. Because this one says, where any Maori is affected by regulations or order in council for the time being in force, and it doesn't date it back. It doesn't date back to legislation that they're trying to get rid of. And then it says, by any act which after the commencement of this act is done or omitted or is proposed to be done on behalf of the Crown. And also in B, it says, by any policy or practice proposed to be adopted by or on behalf. And then in the other one, it had all those dozens and dozens of laws, but they're not existing here. They don't exist here. So I function only within this. So whenever I go to court, I always use number 114. This one has our right to petition to be unaffected. And then there's nothing underneath here that's removed that. So this is the original tenancy agreement, which was done under here of the Treaty of Waitangi. Now, so that is all connected up in this, and it ends in 2007. And then it is, I'm thinking that in 2007, they unplugged us And so this is New Zealand over here, the first tenancy. And then in 2007, which is over here, they unplugged us from the 1841, which is not on here, the Supreme Court, and they plugged it back into England so they can create the new tenancy, which is called Aotearoa, which they've slipped under America. And so that is a new, this is why I'm saying this is the bogus tenancy is over here, where they create all laws that are repugnant. Now, if you see here, we've got this 1993 electoral law as an example. So we've got here the Electoral Act. And under the Electoral Act, which our tenancy agreement says that no foreigners are permitted to govern over us or to even govern within our country, in our place of New Zealand. That is on section, I'll have to go down here a bit. So in the original that was passed in Parliament in 1993, in the original tenancy agreement, which must follow certain rules of the tenancy agreement, which is in our will and Mary, in our will, it says here that if anyone, it just basically says, if anyone has an oath or a declaration of allegiance to any foreign power, they're not permitted to sit in our Parliament. In other words, dual citizens and foreign nationals are not allowed to sit in our Parliament to govern over us in the tenancy of New Zealand. But if you go over to the tenancy of Aotearoa, they waited and then in 2006, they changed it and they inserted a new tenancy agreement. You see there here, it says 1993, and in their new Aotearoa tenancy agreement under a different flag, in their new one, they inserted all of these laws, but the main insertion, they inserted hundreds and dozens upon dozens. And then under their Aotearoa construct, which is in the matrix connected back to England and gone outside of our New Zealand law of 1841 Supreme Court, they inserted 55AA, and they said that dual or multiple citizenship is permissible to be in our Parliament, which is repugnant to our original tenancy agreement. They've come in on the secondary tenancy agreement where they could. So
right.
Now,
so we have to keep in mind that these people do not break the laws. They make sure that they follow them to what allows them to create practices of overreach. So we, by our own actions within society, actually perpetuate that agreement to the next level, whereby you're saying a new tenancy came in, and I can see the work that you did in order how to arrive there, and nice work there, Nancy Drew. But the reality is that if no one says anything, and they have actually made an announcement somewhere along the line that they are moving to a new tenancy, or have to, because there might be some lease agreement that's attached to the original tenancy that's over, let's say a 99-year lease, that's over on a certain date, they have to transcend over to the next one. They have to move accordingly. Everything that they do is, believe me, is not done according to law. They've made sure they put the correct steps so that if it was ever backtracked, then they're rest assured that they've not created any fraud or anything else. Okay, so we got to get that out of our minds. I know people just love the idea that, you know, they're this and have an enemy and everybody's doing fraudulent activity and no, I'll guarantee no one's acting in fraud. The only time that you would actually evidence they're acting in fraud is if you bring in the law, to which then supports your rights of that original tenancy, and you only deal with that law, to which is the correct subject matter you want to deal with. Then they try to overreach it with a subordinate law, to which is that new tenancy. Now they created the fraud. As long as you stay on topic, okay, as long as you state that this is where you want to address this matter, here's a subject matter, therefore this is my status. In fact, I've looked to the oath of the Attorney General within New Zealand, because I'm sure it'll say in there that, you know, he will, anyone to receive this oath cannot be represented by the free and common stockage of any other tenancy agreement. It won't say it in that way, but you've got to, the devil's in the details. You got to read what it says in between the lines, because Attorney General, in order to hold that office, has to be subject based on the subject status that you're speaking about, which is the original. That's where he has to be set up. And I don't know if you guys got lieutenant governors and all that. We have them here: lieutenant governors, governor general, the Privy Council. Okay, and our PM swears allegiance to the monarchy, not to Canada or the people. So just go to that. I mean, it's going to make it really simple for you, that you will not have to now look at what Parliament's doing from this new tenancy. That's no interest to you whatsoever. And anyone that wants to embark on, anyone who wants to embark on the same subject matter that you are, then they should follow how you're going to now affect the correct subject matter in the courts to deal with that matter that's pertaining to the Bill of Rights and those rights that subsequently came in of that original tenancy, which is still, you have to make a determination whether it's a common law interest, which generally it's if it's attached directly to the statute of uses, 1535, and I did some videos on that. But statute of uses is the first use of land that was seen in the common law, so create a new common law title. And that is which then the monarchy has now held in the interest of the people as a common law interest, to which then government has created an equitable use under that. Now, what went to New Zealand? Well, English law. How any law gets transferred into another colony or now to a country, which is just territory law, is it's the land. The law comes in with the individual. All laws within an individual, and they transpose it onto the land as far as it is applicable to those interests in the land. For instance, they would not be battling the feudal land tenure system, because that was abolished prior to, New Zealand becoming a sovereign nation or a commonwealth, okay, under a parliament. So in generality, all you need to do, and don't have to worry about the other stuff or proving anything, of the new tenancy, because it's going to run as if it is, as it is going right now, because people are still following that tenancy. You can't distort it, you can't ruin it, you can't come in with guns a-blazing and say, hey, you can't do this, because it's a separate agreement. And the law only looks to each agreement to find what the obligations you have with that agreement in order to effect a remedy. If you bring in that other agreement and start, poking holes at it, now you've created another issue, to which now brings you out of the true issue you want to deal with, to now the judge has to deal with that new issue you're bringing in. So our biggest problem is, as people, is we get too much information, then we commingle everything. Instead of directly dealing with the subject matter, the judge is not your enemy. You have original judicial independence of 1701 Act of Settlements, but also you have inherent jurisdiction, to which that's the top capstone of the court system, is inherent jurisdiction, to whereby now it transfers a lesser power, which is called an inherent power, that's been transposed onto your New Zealand, and that inherent power becomes the new inherent jurisdiction to govern that interest. But at the top echelon is always inherent jurisdiction. Now you're going to have to go to that court, which would be the High Courts of Chancery, to deal with that subject matter, and that's all you deal with it. You've got to be, focused on answering, only sticking with one issue at a time, and do not go off it until the judge has made that determination based on that question you have. Now, there may be within your own laws tests, and when I say test, I'm talking about certain criteria. It could be 3 or 4 or 5 different steps in order to prove that you have a right to effect that jurisdiction that you're looking at. So I don't know I don't know what the word is, because like you can use the word unjust enrichment and find the test to prove unjust enrichment, or bad faith. You can go into court systems and find out what constitutes bad faith, and then you look at those tests, those questions, and then you fulfill those questions. So when you go into court, the judge loves you because you're on point. But each point within that test, you do not move off, because it creates a latch that if you do move off it and the judge gets you onto some other topic, it's now realized or assumed that that's been dealt with, and you can't go back. It creates a latch. So your focal point would make sure to see if you can find those tests and fulfill the requirements of that test, and then when you sit before the judge, stick with the subject matter of the before tenancy, and then go through each point of that test, and then till that question's answered of each of those, until he agrees with you or says, hey, well, no, we have to do this first, and in order to arrive there, then that's a leave of court. Just hey, I'll leave the court, because you got to get that one question fulfilled. If you go on and go on to another question or another one, then you've lost it. You would have to go to leave for the court in order to get that one question fulfilled. But if you come in properly, as you are now, in discerning what is the true subject matter, then he cannot, then your answer to the test will already be affected by, would be already proven by the law that you brought in. So bring in the correct law, because you only deal with law. You don't need to deal with facts. Just deal with the law. Deal with the tests that support that law of you being subject. Stick with that. Don't bring in the other tenancy in or any other agreements. It doesn't matter. And stick with that, and you win the case. Or what you want to do, which becomes subject.
Well, I'll just share this. I hear what you're saying, and then when I go to show you my 3 court cases, and the judges don't put in everything, they don't put in what I write. They take pieces of what I write, and then they give their rulings based on that. And so I've had 3 court rulings so far. So just before I go to that, and then I'll let you know where I'm sitting with all of this. And because the second tenancy, for a start, they removed the Privy Council from New Zealand through this parasitic tenancy that can't stand on its own, that swims between, it's kind of half connected up to the New Zealand first tenancy of 1841 Supreme Court with the 1844 German settlers. After the German settlers, a New Zealand Maori king also got one of those ordinances. So we had, that king was on the coins. So England came in, English law came in as a scaffolding 1840. 1841, they set up the Supreme Court, but it had no subjects, and they could not make the New Zealand native subjects, and there was no citizenship because they didn't have a country. And the German settlers had their nationality. It's only this one ship had their, now America's got these in the 6 states, come over from England, and they've got their ordinances in England as well. Every one of our country has got a certain amount of ships that came in and they had their nationality removed from them, severed from them. Then they were reconnected up to the matrix on the Supreme Court of each of our respective countries. That's how the Supreme Court of our country, which is separate from England but inherently connected to England, that's how they had to do it. So England came in as the scaffolding, 1841 Supreme Court. The German had their nationality removed from them on the ship before they stepped foot on shore. Then they stepped foot on shore and they were connected up to the Supreme Court. And then the natives were linked on to them. And after the native king was linked on to them, then all their people in the 1865 native rights went under there and became subjects. In 1975, the natives went to the UN and they said, we no longer wish to be under this tenancy agreement. We want to be free. And then, according to the various natives that I've spoken to, they said each of their tribes has created a different tenancy agreement with different instruments around the world.
Can I interject there for a minute?
Yes.
Again? Okay. This is another commingling. You mentioned, you're talking about a race of people, you're talking about kings, you're talking about titles. Let's go to the foundation of English law. English law only deals with land. Okay, so the only issue is not that these people they should not be going and we want to be free, or, ever how the Germans got in to settle within New Zealand. The reason why they're attached to any of their systems is to give them the same opportunity to interact and intercourse and purchase property or land rights. So once you have a land right, or once a land right is agreed to with wherever the court, then everyone's secured under it. That's all the judge is doing, or the court system is doing, is securing that land right, not the interest of, hey, I'm an individual, I'm a German, or I'm the Maori, or whatever. Because what they're doing is saying you have an interest in land to which then creates an obligation, and that agreement to that obligation to land then creates your rules and regulations in order to administrate and use that land. So if you're going to court, we can't be going to court that I have this right and that right. You got to affect what is the land right, to which then you can then settle that land right, and from there have your freedom. But you got to go through the land first. You can't go through the person, because each person has dominion rights, which is not even in the common law, or it's not in equity, because that's a separate interest. You can't even transfer that. Okay, so you got to do with law of persons and law of things. And now that you're dealing with, and English law only deals with land, now you have to go to the land agreement and settle that interest. When you settle that interest, that then has to be subject to a certain status, whereby everyone's a tenant, because there's not one single entity under English law that's not a tenant, okay, except for the monarchy. And that's one thing I'm not really sure, because it's a constitutional monarchy. Did they get a tenancy? I don't even want to get into that because I haven't researched that. But the fact is, the only one that wasn't a tenant was a monarchy. Okay.
Yeah, he wasn't. And what happened was, in 1975, the Maori king. So I'll just show you two documents that I want to show you. the first thing. So, so this is what they've done here. So we've got these two. If you go back over to, so this one is the one that's linked up, that's got various things missing. This is the Aotearoa.
If it's missing, it's because it's a different subject matter that they cannot
Yeah.
put into that same act.
So
it's really, that's what we got to look at, simplicity. We got to say, what's the subject matter? And if they're not talking to it because they went to a different subject matter, therefore it creates a different agreement.
Right. So here's there was the German settlers attached to the Union Bank and the Supreme Court on the number 1, number 2s, right? And what you'll see here in 1847, this is the Maori king. He's the one that set this all up with Queen Victoria. He's on the coins and everything.
Okay, and kick that up for a minute. Yeah, let's see what it says.
So this one says that, you see here, it's been disconnected as well. But this one said that he would receive, they called him, they gave him a name, Thomas Walker Nene, and they gave him a salary to be received 4 times per year. So has been pleased to signify that Her Majesty is desirous of conferring a mark of favour and approbation on Thomas Walker Nene for the valuable services, and particularly for the zeal and courage and loyalty displayed. He's the one that rose. There were a group of tribes that sided with the Catholics and the Jewish religions that were taking over the country. And this king here asked Queen Victoria to come in and get them out, and because they had bought the entire country and all the natives had lost their land. And so this king here, he had asked Queen Victoria to come in and set up a Supreme Court and everything and take all the lands back from those missionaries that had bought it all under a false flag. And so he basically brought in a foreign army to fight his own people. And so that's why he brought in the German settlers as well, because he was not able to get under the 1688, which had forfeiture of properties is illegal. And so he was not able to get under that in his natural state. So first they brought in the German settlers and set up the Supreme Court. And then through that, they were able to give him a paid salary. He was basically perhaps the Maori Attorney General, you could equate it to that. And so he got his annuity, and so did the other kings that were appointed by him. Now,
right. So
wait till you see his wait. I'll show you a second document. Here's the Naturalisation Act, which is in number 14. And you see here, this is not numbered either. And we think this is 297. And this, we think they gave him the name Abraham Kaiser. Now, and this is where he was made a subject, because it's got Thomas Walker Nene's annuity. And we think that they gave him a name. Abraham is something to do with the Bible. And then Kaiser in German means emperor. And this is where he became a subject. And he was to be a natural born subject. So that meant that, and he's on coins, that meant that he mirrored the Queen of England for New Zealand. So he became basically, so he became basically, so all of that. And then this one also had the Savings Bank Act and various other things. So all of that comes under this construct. Now, I just want to show you before I go on, the German settlers that I showed you with the Union Bank. I just want to show you. Hope I can open this. All right. So I'll close that here. Right, can you see here, this one here? This is called the Bills of Exchange Act, and I'm not going to annoy you with it, but what it's got down here is says that the agreement between the Maori and the Supreme Court and the first settlers under the Tenancy Act was that any bills that were created in Parliament to the settlers, so the settlers agreed that they would pay all the bills, but the condition of them paying all the bills for setting up the infrastructure of the country was that they would hold the governance on their own, and that any bills that were put to them, anybody on that AB schedule, which was anybody that are on the schedules that I just previously showed you, could go to protest the said Bill of Exchange. Now, there's actually many more sections in here that talks about that if there's a new bill that comes in, or a new Bill of Exchange that comes in, if the original tenancy people don't have a problem with it, then it can be put through. But if the original people call in their tenancy, then their bill, their protest, if it is in line with their tenancy agreement, which was the well that we have, theirs would trump the secondary bill. Because so that you can see here that I already showed you that there are two sets, and then so that, like what I had showed you here, that there's this set here, which is the original, and then what they do is they go over here, and then this is all the secondary where they insert all of their things. But if the original comes back and calls them to the court, the judge and the court can only recognize the original true and honest agreement, which is here. So, so I, being of the AB descendant, and there are many of these AB descendants, have now entered the court. They made a secondary. So in 2003, they removed the Privy Council from New Zealand, and they removed the right to petition the King. And under my tenancy agreement, that is illegal. They cannot remove my right, because that's what they've done, removed my right. And then they inserted a law. After they did that, they inserted a law to prevent me from calling the parliamentarians to the court. And so I protested that in the court, and the court agreed with me, and the court said they have to come. So then, and that can be seen.
Okay, can I interject?
All right,
again
I'll
here?
stop this here for
Okay.
1 minute.